in child protective services, and they won't give them back to their loving families because they're making money.
This is a legal system that you're going into. And if you don't know the rules, you will be chewed up and spit out.
If I could say anything to a mother who just got their children detained, you're in a crisis. Yeah. Life feels like it's over. The most important thing is regaining custody of your children.
The child welfare system at its core is designed to protect children who need protection, okay? And that's key, is who need protection.
So social workers, out of fear, will remove more children rather than only remove those children that truly need to be removed.
It's okay. It's okay.
This isn't someone stole your car. Someone broke into your house. This someone took your child, your flesh and blood.
It doesn't say on this order that it was not proven. It says untrue. I immediately knew that, okay, well, this ain't over.
Were there signs there? Were there no signs? Did I miss them? Did I catch them? At this point, I honestly don't know.
Families only get a finite amount of time to reunify.
I came into this field to help families, not destroy them.
The difference between the criminal system and the child welfare system is substantial. You have more rights as a criminal than you do as a parent.
Hi, everyone. My name is Georgette Druin. I am the host for Fight CPS Real Talk with Miss G, and Mr. Davis is with us today. Attorney Davis, hello.
Hello. Good afternoon. How are you?
I'm good. Thank you, sir. And also our guest today is Darren. Hi, Darren.
Hello, everyone.
Hi, Darren. Okay, so Darren, I know that you we have some questions here, and I know that you would like to get answers from Mr. Davis. So, Mr. Davis, if I may be allowed, please to read question number 1. Who can stop your visits or communications with your children? Wait. You're on mute, sir.
The social worker can stop them, or the judge can stop them.
What can you do about a GAL when they report that they feel the child should not be reunified and never has spent time with you? What is the protocol for a GAL?
You know, depending on the state, GALs stand for a couple different things. In California, it's called a guardian ad litem, who represents a parent who is not competent to represent themselves in the legal proceeding. But in a lot of states, the GAL is referred to as the minor's attorney. In California, we call the minor's attorney. GALs are completely different. So assuming that they're talking about a GAL, that's a minor's attorney. And, and depending on each state, you might be able to make a motion to have the GAL removed or changed as the minor's attorney.
Okay. Thank you, sir, for that. And question number 3, if reunification is ordered by the judge, what actions do CPS have to take opposed to if the judge agrees with the TPR?
Okay, that's kind of a disconnect question because those are two totally different things that aren't really related to one another. Reunification services are services ordered by the judge to help you be reunited with the child. So, for example, a parenting class, individual counseling, domestic violence, substance abuse, drug testing, those are your typical reunification services. TPR is termination of your parental rights. And as a matter of fact, in California at least, before you get to the TPR hearing, your reunification services have already been terminated or none were ordered to begin with.
Okay. Thank you for that, sir. Question number 4. How do you deal with a caseworker who gets a restraining order on you?
I've heard of this in rare situations. I actually represented a woman in a civil rights case where that had happened to her.
Mhm.
You're going to have to ask that another social worker be assigned to the case, because obviously, if a woman was given a restraining order against you or a man, social
Right.
worker, it's unlikely you're going to get services. It's unlikely that you're going to be properly supervised. I mean, there's an inherent conflict of interest in my mind. So you'd probably have to make a motion to get a new social worker assigned. In California, around the 16,500 sections of the WIC code, there's a statute that says you can make a motion and give some of the grounds where you can ask for a new social worker. You rarely see it though, but in a case that you just posed, the worker's got a restraining order against you, you got to get a new worker.
Okay, thank you again, sir. Number 5, what do you do when a foster family lies about information observed in phone calls, etc.? And more so, what do you do about a foster family not reporting that your child is constantly asking for you, crying, etc.?
Ask for the child to be moved by way of a motion or petition and give those reasons.
Did you hear that, Darren? Okay. Question number 6. What do you do when a CPS agent lies about your actions when your child or about your actions with your child or lies about drug use?
Repeat that. I didn't quite follow that.
Sure. What do you do when a CPS agent lies about your actions with your child or lies about drug use?
You make a motion to have that CPS agent taken off the case.
Okay.
It's difficult. Well, not difficult, but it's kind of difficult for a CPS worker to lie about your drug use, because presumably you might be drug testing, and presumably you can get a hair follicle test that goes back months to prove to the judge you weren't using any drugs.
Okay, sir, I have a question just from me. This one is from me. What do you do when you do go do drug testing, for example, and then the drug test comes back positive when in reality the father or the mother don't do drugs, and then they go the same day to take another drug test and it's negative? So how does that happen when they take you to their own facility? All of a sudden you're positive, and then you do a test in another facility that's not affiliated with CPS with the department, and then it's negative.
Okay, so under federal law,
Mhm.
in order for those drug tests to be used against you, there has to be an appeal and a retest process. A lot of people don't know that. So if you take a drug test and you're going to come out clean, and it comes back dirty for something, you have the right to demand a retest, and you should probably all go and get one of your own tests for, urine. And then, you can even get a hair follicle test or a blood test to further prove that first test was incorrect. Now, there's something that you should know. Drug tests are not 100% accurate. That's in the literature. Okay,
Right.
that's scientifically proven. You can be false negative and false positive. And I once saw a statistical bell curve about that. And the false negatives and false positives are from 3 to 5%. That means that only approximately 90% of the time are the results accurate. So you should become familiar, talk to your lawyer about having a retest and then going out on your own and getting a test, urine, blood, and or hair follicle to prove that that was a incorrect test. I've come across those situations in the last 35 years, maybe 2 or 3 times a year. So it does come up.
Right, because I had a call today, sir, that it was one of the problems they're having is they've never done drugs and they went to do a drug test and all of a sudden they're positive, and then they went the same exactly like 30 minutes, like drove to another facility and they did another one. It was negative. So they called their court appointed attorney and it explained that how is that possible? And then they said that the court appointed attorney told them that just admit you're guilty and you're wasting my time, and hung up on them. So,
Well, the problem with that is not the drug test. It may be the relationship between the court-appointed attorney and the client. And that's a whole nother situation, right?
I didn't even know how to even respond to that.
Okay. Next question.
What happens if a child is 15 years old and the child is demanding to go back home and the child never said that the parents abused her? So it was just an allegation from a child's friend. Basically, the child said, I'm going to kill myself if my mom and my dad doesn't give me back my phone. It was just something that she said. And she didn't mean literally she's going to kill herself. It was just something that she said. And then her friend reported it to the teacher. The teacher reported it to CPS. CPS removed the 15-year-old forcefully from the home. And she refused, and they pulled her from her clothes. And her dad and mom videotaped this while her mom and dad were in tears. And
What state was this?
that's in California.
What county?
Am I allowed to say it?
Yeah.
It's in San Bernardino.
Okay. Whoever that person was, you have them text me or sign them up for a consult. I'd like to talk to them.
Awesome. Thank you, sir. So is there a particular age where the child can refuse to go and they cannot force her to go?
No. I know you thought otherwise, but the answer is no.
I was told, okay, if I may, I was told this, there's an age limit. Basically,
Wait. Who told you this? The guy at McDonald's or the lawyer?
One of the CPS attorneys in Monterey Park that you know as well. She knows you and you know her. I will text you the name later. But she said that age 13 and up, they cannot force the child to go with them in the vehicle if their child refuses to go with them, with the department.
All right. Well, I gave you my answer. Next question.
Thank you. Okay. All right. So, can a child be interviewed without the parent at any given time while the child is in the parent's home?
That's a very interesting question, because it depends on whether the worker has a warrant to conduct an interview or not. And even if the worker doesn't have a warrant to conduct an interview with the child, there's a very gray area in the law about whether a social worker can do that or not. And there's a case right now, a civil rights case. It may have settled already, but it's going on right now in California, in a different county than ours. And that's the issue. Does a worker have the right to come to your home or go to the kid's school, pull the kid out and talk to the kid? They do it all the time, right? But the Ninth Circuit here in the Western United States may decide, hasn't yet, I don't think, may decide that that's unconstitutional. But here's the problem. If the worker does it and the information is used in the CPS case, there's no rule of exclusion of that information. You can sue them later, but that's not going to help you in the CPS case. So like in a criminal case, if they wrongfully gain information excluded from the criminal case, right? Not in a CPS case. Even if it's illegally obtained, and it violated your civil rights, the social worker and her attorneys can still use it in many cases. I have seen a couple of occasions where the judge said, that's so outrageous, I'm not going to allow you to use that. But, I could count those on one hand. So don't think that just because your rights were violated, that's going to help you in the CPS case. I get those calls all the time. Hey, I was arrested by the police. They dropped the case. Why don't I get my kids back? It doesn't work like that. They're two separate legal systems. It's like, the OJ case, for those of you are old enough to remember. OJ was not guilty in the criminal court, and they took the same case across the street in the civil court. He lost like $45 million. How does that happen? Two different systems of justice, two different systems of evidence, burdens of proof. In some of my cases and talks, I talk about burdens of proof and evidence. And for, people that are not lawyers or didn't go to law school, that concept, doesn't really, in my mind, spark the interest that it should within you, listening to a case or evaluating a case. I just won a big case last week in Sacramento. And at the beginning of the case, the mother's mother, not even my client, and her best friend were always grilling me about this case. What are you going to do? Why aren't you going to do this? Why aren't you going to do that? And blah, blah, blah. On and on. I swear to you, I might have talked to them 15 hours about stuff that they just didn't understand about evidence and procedurally.
Right.
Now, luckily, as fate would have it, I win the case. The case is thrown out by the judge, and the judge orders them to return the kids immediately.
Wow.
Right. But it was all about evidence. It was all about evidence.
Right.
And this particular judge was sharp as a tack, and the judge knew the evidence code, and she realized, the arguments that we were making. She, like, wow, the social worker just didn't have the evidence.
Did the judge really know this, or were you just a great attorney at it, that the way you represent the evidence into court? I mean, because I really see judges doing the opposite.
I put my pants on one leg at a time. Okay, I'm not Superman. Just
phone booth. He goes in the phone booth, comes out.
I try to, do my best that I can do. That's all I can do. And we should hope that every lawyer, member of the bar in every state does the best that he or she can.
I understand that.
Whether they do or not, I don't know. I'm not there.
I understand that, sir. But the point I'm trying to make is that, I mean, there's a lot of attorneys that have evidence, and they choose not to submit it into court, or they say it's irrelevant, or they don't have time.
I don't know if that's true or false. I'm not there. I haven't analyzed the case. I talked to someone earlier today, and she told me about the case, blah, blah, blah. And she wanted me to tell her whether she was going to win her civil rights lawsuit against the social workers. And I said, there's no way that I can do that. We had like a 20-minute conversation.
Mm-hmm.
I said, if you want me to give you an intelligent, cogent analysis, send me your file and I'll look at it. Well, why can't you tell me now? Well, even a doctor can't look at you and tell you whether you have cancer or you need an operation, or you need heart bypass surgery. They got to go in. They got to look at the charts. They got to look at the x-rays and the ultrasounds and maybe do exploratory surgery. I'm just not a magician.
No, I understand that. I totally understand that. So when somebody's dealing with a court-appointed attorney, right? And the court-appointed attorney tells the parent that you're going to lose your children if you do not admit that you're guilty. And the parent refuses to admit they're guilty, and then they end up losing their children. do judges know that that's what the court-appointed attorney tells their clients?
No.
What if okay, what if that particular attorney does that with every parent, and every parent actually has the same thing to say about this person, him?
That would be a very unusual situation statistically, but there's no way that you would know whether he did that with every case. You would know if he did it with a lot of cases, but most court-appointed attorneys have 200, 250 cases, maybe more, and you might have 20 people that came forward and said, well, he told me the same thing. That doesn't mean that the court-appointed attorney did that with every case. You have to be careful of the accusations and the conclusions you draw.
Okay, but however, let me just say, however,
you can say he did it with a lot of people.
Okay, most people, most of his clients,
Have you talked to 125 people?
There is 228 people that complained about the same man, to the point where they put the picture of him, of that attorney. He's actually the head of the attorneys. I can't say what county, but you know him as well. And they all say the same thing. He said, I have to admit I'm guilty, or else I will never see my kids again. And they all said the same thing. 220 something people said the same thing.
After the show, I want you to send me a message of the person's name, because I find that hard to believe. I find it hard to believe.
Now, right here. I'll do it. I'll do it. Right now, Mr. Davis.
Only because I don't have all afternoon. I have to move to my next appointment.
I understand.
So, Mr. Davis, what if you are a parent and you are concerned with something being in your case files? Say, like you're saying, that the lawyer says it's irrelevant. However, somewhere down the line, you feel like it may pose an important part of the case, or maybe the lawyer's just not listening to what you're trying to prove for them to understand. What do you do as, I guess, as the concerned parent being represented, to ensure that the information that you'd like to get through to the judge, or even just in the file so the judge has it to view, what can you do to ensure that your information gets to that point?
Okay. Darren, that
Yes,
is
sir.
one of the best questions anyone's ever asked me.
Oh, thank you. Thank you very much.
I'm going to give you an answer. I'm not sure you're going to like it, though.
Okay.
What? Uh-oh, the lights went out. Hold on.
Well, I guess I won't.
That was classic. Okay, here's what you do, Darren. You do the same thing I did when a doctor told me that I should have a thyroidectomy. You go and get 2 more opinions from people who are known to be experts in the field. I don't know if you've ever heard this story, but many years ago when I was married, my wife was alive, a doctor told me to have my thyroid removed. And I said, oh, okay. And I scheduled the operation. And a few days before the operation, my wife says to me, I've been holding my tongue, but I need to tell you this. You're a smart guy. Why don't you get a second opinion? And I'm like, I guess that's a good point. I go to the second opinion, and I really didn't like the doctor, but he was, a specialist in this area, and nationally known. And he basically laughed and said, whoever told you you needed a thyroidectomy shouldn't be practicing medicine. Now, I don't really like him, but I didn't know whether to believe him or not. He didn't run any tests. He looked at all my medical records. Now you can just order a copy of your records on CD and send it over to the other doctor. So I went and saw a third doctor, who sent me to a fourth doctor for tests. And the third and fourth doctors, they talked to each other and everything. And they weren't as harsh as the second doctor, but they said, Davis, you don't need an operation at all. We're sorry somebody told you that. That was probably 15, 20 years ago.
And here you still are.
Here I'm still am. No thyroid problems. I did get some treatment for a few years regarding the issue, but suffice it to say, I'm still here. Suffice it to say, the answer to your question is go talk to a couple other lawyers.
Mm-hmm.
Are you going to have to pay those other lawyers for that opinion?
Mm-hmm.
I had to pay my doctors.
Right.
For that second and third opinion and that fourth opinion. Right. They ended up doing a complete analysis of my thyroid with ultrasound and something called fine needle biopsies. Right.
Wow.
Mm-hmm.
Now, I don't know if you know this, but the thyroid is like a really important organ in your body.
Yeah, very, very, very.
It regulates your blood, your body temperature. It regulates your body temperature. Without a thyroid, you're in trouble.
Yeah, you're in deep trouble.
You take these big pills, they're huge pills, and you have to take them every day. So that was just my thyroid. You're talking about your kids.
So that should be 10 more. That should be 10 or 20 more opinions than if that's the case.
A couple, at least a couple. Well, Mr. Davis, they're going to charge me, $500. Okay. Are your kids worth the $500? I hope so.
Yes,
well,
yes, they are.
Mr. Davis, I don't have $500.
Figure a way.
Yeah, you got to find a way because you need that opinion. Or here's the alternative: take the lawyer's advice because you're not a lawyer, and go with it.
So, is the case file itself not relevant as they tend to make it seem? Is that
what do you mean?
So I'm saying because according to the way the law and everything works, right, the judge doesn't see anything about the case, right, until the morning that you go in to your trial, for say, right?
No, that's
okay.
A lot of people think that.
Right.
Has it ever happened? Maybe. But when I do trials, and you might find this surprising, I get the sense that these judges have looked at everything.
Okay.
And then sometimes they ask questions, themselves. Look, in order to ask an intelligent question of a witness, you got to know something about the case. So don't just be, you didn't see the judge review the case because you're not in the judge's chambers. You're not at home on the weekend with the judge.
Right.
Never assume that the judge doesn't look at the case. That's a bad assumption and a really bad strategy because it affects the strategy. It affects how you are going to come across in the trial. Assume the judge knows everything. All right. And go from there. You got the law, you got the evidence on your side, present it with cogent legal arguments. Now, are you qualified to do that, Darren?
No, sir.
Probably not. You seem like a really smart guy, but
I don't have the same certification as you, though.
Right. And just like if you needed open heart surgery, you wouldn't do that. And I use this example all the time. Many months ago, my auto dealership told me I needed a new transmission. I'm a smart guy. I don't do transmissions. And you know what I didn't do? I didn't run out to Pet Boys and buy the Chilton book on my car for my make and model and year. I didn't buy a whole bunch of tools and supplies. You know why? Because it would have been a complete disaster. And when I talk a lot of time that they're going to try to do their own case, a civil rights case or CPS case, 1 out of 1,000 people are going to get lucky and win.
Right.
999 are going to lose because they shot themselves in the foot.
Right.
I tell people, don't hire me. Find someone that's a lawyer that can help you in your area.
And see, my question wasn't so much to go at like a pro se or whatever you would call it in that defense. It was just to be concerning to the fact that in certain cases, if you are status to be with a public defender, you kind of have that concern that they're not doing everything in their powers to help you, for say no motions, no appeals, no objections. So when you're coming down that line and you start to worry, how can you, because not everyone in this world is fortunate, are able to come up and do that. How can you be sure to the best of your knowledge, I guess is what I was saying. So, okay, let's say we went and got the opinion, like you said, and, 5 or 3, however many opinions you got, say, you know what? Yes, Darren, that is, the right thing, what you're telling your lawyer. Then you would say to your attorney, I want this done. Or would you say, listen, sir, I've asked and they feel like it's relevant and it's relevant for these reasons?
Yes, you would demand it to be done. And if they don't do it, you can have what in California, it's called a Marsden hearing. That's basically whether you can make a motion to fire your court-appointed attorney and get a new court-appointed attorney appointed.
Mhm.
Talking to someone the other day, and I said, make a Marsden motion. I made a video on it. And she said, oh, I saw the video, but if I fire my court-appointed attorney, I can't afford to hire you. So now I'm screwed. I said, no, Marsden means you fire your court-appointed attorney and you get a new court-appointed attorney. If you could afford to hire a private attorney like me, you don't need a Marsden motion. We just do a simple one-page form called a substitution of attorney. I come in, you sign it, they sign it, I sign it, and I'm the new attorney. No Marsden needed.
Because,
If you want a new court-appointed attorney, make the Marsden or whatever they call it in your state.
Right. And the only reason I'm just asking, because you have a strategy, right? For say, when you go into a courtroom with your client, you've come up with your game plan in your head, how you're going to question this person or this person and this person. And therefore, what I'm getting at is maybe the information I'm curious about might not fit into what your game plan would be. Would that be one of the reasons possibly an attorney may strike you down and say that's not important, or because you don't understand? So
absolutely, because
Okay.
people, Darren, you might form a strategy about your case.
Mhm.
It may not be a very good strategy, but you don't have no way of knowing that.
Right.
People are always talking about, well, it's not fair, or it's this or that. On my YouTube channel, I did one of the most important videos I ever did was called "What is Justice?" Because Darren, justice isn't what you think it is, and everything that you do, you're doing it from a frame of reference of what you believe justice to be. I don't know, how old are you? 35 years old?
43. Thank you.
Okay.
Thank you. That's
So,
nice.
so
Really good.
43 years, you've believed justice is this. 43 years. When justice really is this over
Right.
here. And for a lot of people, I can't even convince you, Darren, that you might be a little incorrect on this because, it's so close to your heart. It's so emotional. These are your kids you're talking about.
Yep.
Mm-hmm.
I tell people that, people call me, how are you going to do blah, 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 blah. I said, no, this is what I'm going to do. I'm going to get your kids back. That's what I'm going to do.
Right.
Well, I want to do blah, blah, blah. No. I want to change the laws. No. Right? You should have one goal. Get your kids back. Everything else doesn't matter. And a lot of people find that hard to deal with because they want to change.
They want to be in the driver's seat.
They want to be on CNN. They want to be on the news. And they want to win.
Excuse me.
I have a reminder for Big D.
You can't have all of those things at one time. Now, I tell people, get your kids back and then do what my grandmother used to say. Get even.
Right.
After you get your kids back. And getting even means, you file that civil rights lawsuit. 42 USC 1983, the federal law, it's a big hammer on social workers that lie, cheat, and steal.
The three worst kind. Now, in that, since we were talking about the caseworkers lying, I know that everybody throws around that name of, that ruling of perjury, which is a very difficult thing to prove because you've got, there's a lot of steps in that manner. However, if you know that you could get to an actual perjury ruling, meaning that that the police department would accept it and charge, and then the district attorney, because you followed the guidelines, because there's those things that it has to actually match, like it has to be in a courtroom, it has to be on a docket, to show that it was, it can't just be they said it and he said, she said stuff. Is that an avenue that you would pursue as an attorney if you knew that you had lock, stock, and barrel a perjury charge against a lying CPS agent? Would you use that for the matter of trying to obtain the children back, or would you save that for when you go into a civil context and try to win the money? Or is that something that can be used both ways?
It depends. I mean, that's a very general question and very fact specific. But I will tell you this. Why are we talking about perjury if you don't have the kids back? I just told you there's only one thing that matters.
Right.
And that's getting your kids. Now, if the lady or social worker lied, that's something we can talk about next month. Right? This case that I won in Sacramento, last week in this other Northern California county, it hasn't even been a week. Maybe it's been a week already. She's texting me off the chain. When are we starting the lawsuit? When are we starting the lawsuit? And I'm like, relax.
Enjoy your child.
Right. Relax. Right. We'll get there. All right. So the first thing was getting the kids back.
Right. And then again, like I wasn't looking at it as the monetary reason. My question was more or less for because preponderance amount of evidence is where we're working here. Is if where there are so many lies based on this, and then for instance, possibly there's the restraining order, which was gotten from the lie that it is a provable perjured move. If a judge sees all of these things, but then says, whoa, wait a minute, we have a ruling that says over the line that says that this was in fact lies, opposed to allowing that caseworker to work on that preponderance level of evidence, I didn't know if that would be a helpful tool, if you will, to get to get what you want, because there seems to be so much people saying that these caseworkers lie constantly. If there's a checks and a balance that's available to anybody that no one that you would use, even for instance, that you'd say, wait a minute, these lies, because we know all of us that deal with this, the preponderance amount of evidence that's not even a little bit of it. Could be possibly someday, maybe that person didn't even say it, but might have, so to impact, I guess, your case, if something along those lines, if you had some tool that people could use to say this person was lying to help in that whole mindset. That's kind of what I was asking about to you in that question way. Opposed to, I mean, that's obviously monetary is what everybody would hope for. I and myself want my kid, and that's enough money for me. But I just see it so much that all these people talk about how they lie about you, and it's not, just one place. It's all the time. You even yourself say that it's constant. So is there something that you do, or you work towards, or you're trying to work towards to stop this, that you could, maybe spread and help these people, or maybe stop this from happening?
No. You know what I work towards? Every family that I represent, every parent that I represent, I focus on getting the kids back.
Right.
I assume social workers aren't going to tell the truth.
Right.
I assume that. Okay. And we make our case and develop our defense and our strategy, assuming that.
Okay.
You got to focus on getting the kids back first. Somebody Georgette asked me the other day, can you sue a social worker even though you don't have your kids back? Yeah, you can. I think it's a very bad strategy.
Right.
The better question is, do you think I can win a civil rights case if I don't have my kids back? And the answer to that question is, well, depending on the case, but probably not. See, a lot of people ask me, can I do this? Can I do that? That's the wrong question. The question is, how can I win? That's a really hard question.
Right.
I want to actually go back to that comment you just made about me asking you about that. However, can you explain to the people that, because from my understanding from you, you said that in order for you to sue a social or CPS when they have custody of your child or children is if there is any evidence of abuse in the foster home, abuse, neglect, trauma, severe trauma.
That's something completely different.
Okay, but you can't just sue a social worker without any type of evidence of abuse. Am I right?
Listen, frivolous lawsuits are filed every day.
Mhm.
In California, I don't know about other states, you can sue anybody for anything. Now, does that mean you're going to win? No. I mean, theoretically, Georgette, I could sue you right now for wearing hoop earrings.
Oh, she looks so good in those.
And you could say that that's ridiculous. It is ridiculous. That doesn't mean I'm going to win.
And it doesn't mean that you can't sue for it, right?
So when people say, "Can I do this?" Yeah, you can do that. That's the wrong question, but you can do it.
Right. So, that's if I okay. Go.
Darren, hold on a second. Let me just ask this one last question. What if the parents want to decide to hire an attorney for their kids instead of dealing with the court-appointed attorney that they allow or they assign to the children's attorney? Can a parent hire a child attorney instead of dealing with the court-appointed one to the children?
In 35 years of doing these cases, or being a lawyer, let me put it that way. I think I've seen it happen once or twice. And I've seen it refused many, many times. Because in California, the court gets to appoint the minor's attorney. And the minor's attorney has to have special training and education and experience. Most lawyers aren't going to have that. They're not even going to qualify to represent a kid in a juvenile dependency case. The last time I saw someone try to do it unsuccessfully, the judge asked the attorney some very basic questions about juvenile dependency law. The attorney got every question wrong. And there might have been like 4 or 5 questions. So as painful as it is to say, that attorney wasn't qualified at all. Forget the experience. The judge didn't even get to how much experience do you have?
But Mr. Davis, even the court-appointed attorneys, the child attorneys, they don't even speak to the child in most cases, and they say
you don't know that, Georgette, and neither does any parent that you talk to know that. They suspect.
What if the child said it?
They suspect it. Right before this, I got on this Zoom call. I was doing a Zoom meeting with a client, and at her house was the children's attorney's social worker who went to see the kids, check them out, and she writes up a report, gives it to the attorney. That is legitimate. That is legitimate. So you could technically say, well, the attorney never spoke to the child. I guess that's true, but the attorney's social worker, not assistant, this lady is a full-blown social worker, did go out and interview the children and laid eyes on them and, asked questions and, saw the house and the, surroundings and everything like that. So sometimes, social worker attorneys don't speak to children because they have, not social worker attorneys, children's attorneys don't speak to the children because they have social workers that do it. Now, has there ever been a case where a child's attorney never spoke to the child and the social worker never spoke to the child? Yeah, I'm sure there has been. I'm sure there has been, but that's a red herring in the case. That's a red herring. You know, a lot of times, it's a very emotional thing. You lose your children. You're very, you're reaching and you're grasping at straws.
But
And
wouldn't the
pardon me.
sorry, go ahead.
No, pardon me. Go ahead.
Wouldn't the attorney would want to see the children instead of depend on the findings of the social worker?
No.
Wouldn't the
You,
attorney want to meet the children really to make sure the social worker is accurately writing these things down? Because I did speak to an 18-year-old who grew up in the system,
no.
and he told me that he's going to be on my show, and he told me that the social worker, he's never met the attorney, his attorney. He said the social worker did speak with him and told him that his parents didn't want to see him anymore. And then later on, he found his parents, and he said that wasn't the case because their parents were trying very hard to see their kid, and the social workers did not allow them. But they told the social worker told the child that your parents no longer wants to see you, so he had resentment towards the parents. And
I believe that.
well, that's wrong. That's very, very wrong. So for us to think
Hey,
that
Georgette,
they're doing the right thing is wrong.
Georgette, how many things do you see are wrong in life?
How many what, sir?
How many things do you see on the news every day that's wrong in life?
Everything.
Right. And you can assume because people are involved, there are going to be cases just like you described. Now, you know what you do in that case? That young man should bring a lawsuit against the social worker.
After 18 years?
Yeah, he has a great case. The statute of limitation doesn't start running until you turn 18.
Okay, everybody.
And then
heard that.
and it lasts for 2 years in California anyway.
Okay.
So that 18-year-old, if presumably he's in California, I don't know if he is, but if he is, he has until he's 20 to sue the social workers.
Good to know. I'm glad you said that because I do get a lot of calls like that.
If he was sexually abused by the social worker or the foster parent, he even has longer than that to sue.
Okay, sir, I have a question about that part. Do they need to show because would it be because see he said he told his social worker several times he was being abused and he would go to bed hungry at age 7 and the foster parents would not feed him if he doesn't listen to them. So he did address this to the social worker, and the social worker said, well, you have nobody else wants you, so you're gonna have to like deal with it. So how could he prove that the social worker told him that? This guy is dealing with a lot of trauma.
It would be just his own testimony. And then it would be up to a judge and a jury to decide if he's telling the truth. That's how our system works. You've been watching Johnny Depp and his girlfriend, right? She says ABC, he says X, Y.
Right.
Guess what? The judge and jury is going to decide who's telling the truth.
Exactly.
That's just our system. So this young man has his testimony. Whether he's believed or not, that's up to some jury that hasn't even been selected to hear his case.
He also have a psychiatric reports from several psychiatrists who actually did reveal the trauma he's facing is from abuse.
Perfect. That helps a lot.
Better, right?
Because he's been talking about it since he was 7 years old.
Yes, he has.
Yeah.
Okay, that's good to know. Thank you.
If I may, I used this on the show earlier, and I read this often, Mr. Davis, and I know that your time's probably coming near here, and you're going to see all of this from me anyhow. But let me just, if I may, I want to read you this statement and tell me what you think or what you may have even your thought process is. Okay. This says, it may be difficult to see in writing very specific information about the facts that led to this decision. Now, if you receive that as a letter about one of your clients, and that's the first line from the state to you about their ruling. What is your thought process?
is going to have to take a review and an analysis of the case.
I know, I'm just meaning in a generalized way. For them to say that they have it's difficult to see in writing very specific information about the facts that led to this decision.
Darren, see, here's the problem.
Mm-hmm.
Here's the problem. You're 43 years old.
Mm-hmm.
I'm going to assume you've never been a lawyer and you've never been to law school.
Good assumption.
Okay. I'm 63 and I've been a lawyer over 35 years.
Right, as long as I've been alive, absolutely.
So what it means to you is different from what it means to me. And I'm not saying you're wrong, but you asked me what it meant to me.
Right. No, and I'm not trying to make it into anything. What I'm just saying is the description being so vague is to say that there's no words in the English language that can be used to describe this, or does that scream to you they don't have facts? They don't, and I'm not asking you to just determine on my sake. I'm just saying in a in a generalized way.
I don't know. I don't know anything about the case. I don't know anything about what happened. It's like walking into a conversation between your two best friends in the middle. You don't know what they're talking about.
Right. No, absolutely. I understand that. I was just, I guess, more or less speaking of the vagueness in the, in that's all. But not in the.
Okay. I want to just one last.
Hold on a second.
Oh,
I'm sorry. I do have to go. Someone just walked into the conference room and to remind me I have a 4:00 Zoom meeting on another case, and it's actually 4:02. So, Georgette, if you want, we can pick up tomorrow.
yes, sir.
Be happy to do a show with you. Talk to you guys later.
Thank you very much, Mr. Davis.
Darren, take care. Bye-bye.
You'll be reading soon this afternoon.
Okay, so I want to answer this question. How does one go about suing a social worker in civil or criminal? Is it a Supreme Court state level? Mr. Davis says civil. It's always going to be civil. I want you guys to understand that a lot of you guys have been asking people who are not attorneys, child advocates mostly. I want you guys to understand that I'm getting a lot of people telling me that the child advocate gave them the wrong information. So they're not attorneys. Please, I'm begging you, do not listen to anyone who is not an attorney. Please, I'm begging you again, do not listen to anyone who's not an attorney. Mr. Davis just literally said that to Darren.
Mm-hmm.
Mr. Davis even had to get a second opinion himself for a surgery that one doctor said he needed, which he didn't need. So again, you do not get advice from someone who's not an attorney, period. Okay? This is the last thing I'm going to leave you guys with. I am going to start my Relatives Fight CPS with our guest today. I believe her name is Amy. So I'm going to have to say goodbye to you guys for now, and I'll see you guys in a few seconds. Darren, I'll see you in a few seconds.
See you in a second.
All right, baby. Bye-bye.
Bye-bye.